I owe no $4,000. I only owe $3,277.59, and that needs to be the balance of the owner arrears.
The number that is on
you don't add $1,000. No, ma'am.
Yes, ma'am. Yes, ma'am. Yes, ma'am. The number that is on the system is not an updated number. The number on the system, once again, is not an updated number. It is behind. Stop unmuting, because the more you talk over me, I will continue to mute you. I'm telling you that the number shows up on the system.
What's good, everybody? You know the vibes. Your boy Day back at it again. Make sure to like, comment, subscribe, and hit that notification button, and we're going to get right to it. So we're going to be reviewing this video, getting my reaction. I might be intervening within between. If you don't like it, you can respectfully leave the channel, or most likely I'll put the link below for you to go see the full content. Let's go.
The more you talk over me, I will continue to mute you. I'm telling you that the number that shows up on the system is not an updated number, but you refuse to listen to me. So Mr. Tell us basically she's going to have to start paying you $345 and additional $69 starting April 1st.
Okay. You said 30. You said she'll pay me what now? Let me write this down.
$345 plus an additional $69 a month.
Okay. So what if that's not met?
Starting April 1st.
What if that's not met? Because it's kind of been just like she'll start paying, I guess, when the court date is coming up, and then it just goes away. And my son is still, I'm fully with me, and I'm just trying to figure out, like, I guess I've been on the other side of things before when I haven't had a job and, haven't had, been on child support. And I've just seen the ball start rolling a little bit faster with license being suspended, the possibility of incarceration, things of that nature. When will this?
What we can do for Mr. Teller?
Yeah. Okay, Mr. Teller, this is where we are right now. This is an adjudication of arrears, which means we needed to get that dollar amount solidified so that it's now a debt owed against her. It's never going to go away. So we have that in place. We're also going to monitor her payments. If she's not making her payments after 60 days, then automatic suspension for admin things such as driver's license, passport, tag, that starts. At the end of 90 days, the case is normally referred over to my department, which is where we are right now, for review for a contempt action, because she's eligible for contempting now. If the court finds that she's in contempt and she's not paying and she has the ability to pay, then what will happen is she will go ahead, the court will set a purge. If she doesn't pay the purge, then there's the possibility of incarceration. I need to caution everybody listening in that this is civil, this is not criminal. So Judge Manning doesn't have the legal authority to just lock someone up until they pay the full balance of a purge, because that's what we call debtor's prison, and you don't have that anymore here in Georgia. If she is not working because of barriers to like education, criminal records, or things like that, there are services that we can help give her that will get her on track so that your son is getting, or you're getting assistance for your son as needed. And because we've adjudicated this, I believe we may have Ms. Freeman reach out. I need to think about that and see if she's eligible for the PAC program, or if she's not employed or something. But those things are happening right now. So nothing's different depending on whether you're male or female, mom or dad, whoever is supposed to be paying that money to child support, the same steps happen that happened before.
Okay.
And as far as we're concerned, it's only about your son at this point. We play no favorites here.
Right, exactly.
Or at least I don't.
Yeah, I surely do appreciate it breaking that down for me. I just want to know how the process went, and that's kind of clearer. So, like, we're looking at now, April. You said, this 345 plus the additional 69 to start.
Yes. And if she's not paying child support like she's supposed to consistently now, then they'll start reaching out to her to ask if she needs services. And if she doesn't respond, then the regular, we have to do the admin part first, which is suspend licenses and all of that, and then it can come to contempt. And unfortunately, we may have to ask you to come back to say that you haven't received anything later on down the line, but that's how the process will go from here on out.
Let me add this, that I know she hasn't had a license in years due to suspension of her license for drunk driving and things like that.
We don't need this because
I'm sorry.
Okay.
I'm sorry.
That's okay.
I'm sorry.
Yeah, that's okay. That's okay. I understand.
But I guess my question is that a step that gets skipped if that's already has happened?
No, unfortunately not, because the way the law is set up,
I get it when people are in this situation where they already like have the court in their favor. Sometimes it's best to shut up. Don't say certain things that's irrelevant because it might ruin and jeopardize your case. They're already telling you that you're in the right, she's in the wrong because she's been missing child support payments. She's gonna be paying. The court is gonna issue everything for her to pay, and if there's anything that she missed, which he mentioned that she doesn't pay from time to time, it will all be backdated and paid for. So the last thing you should be doing is trying to include something that you didn't include, because then now they're gonna feel like you're trying to get more out of her or trying to punish her. And 9 times out of 10, they might just lower the child support in that aspect. So you might as well just shut the hell up and just be happy with what they're giving you, bro. Because as a man, I ain't gonna hold you. You're very lucky to be on that other side of the table. They usually don't even grant you nothing. Like, it don't matter. Some mothers could be abusive on certain like controlled substances, and still they still get custody. So you got to be very careful with that situation, bro. But let's keep going.
We've had this case. We filed this case a while ago. So she may be eligible to be looked at for contempt more quickly if she's not been making payments consistently. I don't have her last on my notes. Agent Ms. Freeman, can you see when her last payment was?
Her last payment was made on January 31st in the amount of $85.80.
Okay, that's relatively low. So, but a payment was made, and so that's going to trigger the clock to start over. But what I'm going to ask our PAC coordinator to do is reach out and see what's going on.
I mean, I'm kind of looking at like all of the boxes here on the Zoom chat. None of it really shows the mother. It mainly shows all of the court representatives, people who work in court. Like I see DCSS here, mainly DCSS, mainly like about two DCSS, and then a PAC coordinator, and then we got the judge, and then the lawyer, and then another lawyer down there, and then the father of the child that's basically on the bottom right corner. So I wonder where the mom is at, but I believe they're gonna bring the mom up.
You can for me?
Yeah, I'll
and
go ahead
then
and
let
reach
me
out to
know.
her.
Because if I do need to file something, I can, if she can fit into the program, so that we can get consistent payments in. Okay, Mr. Tillis, I think you've heard Judge Manning talk about the PAC program a little bit, and what that's called is parent accountability. And what's different about that from fatherhood is that it's governed by the court. She still has to report to another judge, Judge Brasher, who meets with them once a month, and then Ms. Freeman, who is on the call with us today, will monitor her. She has weekly contact with the participants of PAC to make sure that they're on the right track to do. And if there are any other barriers, she can help provide services from the state. Not that this is the case with the current CP, but say, for instance, if a criminal record is preventing them from being able to get a job, the state will provide what's called a bond to assure the company that there will be no problems, and then that person can go work. So if there's a job out there, Ms. Freeman will find it for her.
There she is.
Okay.
There she
Will
is.
I get a copy of this?
Oh, she's back.
Oh, okay.
Order? Yes. Okay, I believe.
Okay, that's the mom right there on the bottom right that just popped up. Her name is Shari Amore. That's what it says on the name. But let's see what happens. From the look of her face already, you can tell she's pissed. Like, she's pissed. I see something happening. Hey, let me chill. I might be reaching, but I see something happening with her face right now.
Well, okay. Well, we're done. So, Ms. Pate, what's happened is this was an adjudication of arrears. This is the last case on the calendar. And so the court proceeded to go forward because we need to let Mr. Tillis go back to work. The arrears were adjudicated at $4,292.59 as of February 28th. Your current child support payment is $345, and a repay of $69 has been added to begin on April the 1st.
When I looked into the system, the child support balance is only supposed to be $2,900. When I looked into the system, the child support balance is only supposed to be $2,932.59. That's the amount that's in the system. What's the $4,000?
Because when you look into the system, we can only start charging for the amount of time until we get to this, which is an adjudication of arrears. Mr. Tillis provided what's called an affidavit, which was in the packet that you received when you were served. And that's the amount that we are adjudicating right now. That has been added to that $2,000 in the system to bring your total up to
But you're not supposed to add that to the
$4,292.
$2,000. That's included in the $2,000. The reason why I'm saying that
That's what court is. That's what court is for. That is literally why we are here
what
today.
I'm saying is,
hold on, ma'am. Listen to Ms. Clark Davis.
I hear her. No, what I was saying was the $1,000.
Talking over her, so I'm muting you. Go ahead, Ms. Clark Davis.
So we can't put on the system the arrears affidavit until the amount that's on the arrears until we've had a hearing. We had a hearing today, and we added that information to the system, which is why the total is now combined to the additional amount. The other thing was this case did not have an arrears repay added to it. So that's where the $69 extra a month is coming for to pay down the balance. Now, if you have proof today that you have paid Mr. Tullis that money from the affidavit, we're open to seeing the receipts.
Okay, but this is what I'm saying. When we received the complaint for child support,
so basically what the court is telling her that it's like it's back to the payments. There's payments that's like that wasn't met, that she didn't pay, and then she's basically trying to say that no, well, the only payments that was there was around $2,000 and some change. But what they did was the ones that wasn't paid, that they had previously agreed to for the amount of $4,000 and some change, from them calculating the missed payments, she's not trying to have it. She's saying that the only ones that she missed is basically it's only $2,000 and some change, not 4,000 and some change. And she's basically trying to like dispute that right now. They say if you have any proof that you've made the payments and you have any receipts, you just show that, and then we'll just call it a day. But she's like just going back and forth with them because she's seeing that the rate just doubled. I can understand that, but in stuff like that, it's best to just be quiet and listen, or just get an attorney. But in this situation, you can tell she didn't get an attorney, and now she's about to go off. So let's keep going.
Says that we owe the $1,360, and that's as of 7/7/2022. The only thing that's added to the $1,360 after that is the $354 that's supposed to be paid monthly. Mr. Tullis has received monies through IWO, and he's also received monies through direct payment. So another arrears affidavit needs to be completed by Mr. Tullis. As of January 31st, Mr. Tullis has received at least a payment of $1,000 on the case. Although that arrears balance needs to be done over this, the $4,000 is not correct.
Your Honor, do you need to hear the testimony again with Ms. Pate currently present, or does the court want to rely on the testimony that was given earlier?
I mean, I heard this testimony was given earlier. I'm fine.
So that's what I'm saying.
Your Honor,
so if the system says that I only owe $2,930 something as of January 31st, then we don't add the $1,360 to the $2,900. The $1,300 is as of July 2022. The $2,900 is as of February 2023. If we do 3 times 12, that's like what?
She's frozen, and I'm absolutely happy with I mean, she hasn't presented anything other than what she thinks that the math is done wrong.
Now the judge funny for that. Let's keep going up.
Thank you, Your Honor. Then we'd ask that be the final order of the court. Mr. Tullis, am I frozen too?
Yes, ma'am.
Oh, okay.
Yes, ma'am.
All right, Mr. Tullis, then everything stands as we discussed just a moment ago. Ms. Freeman, I still need you to reach out to Ms. Pate when you have a moment to see if she needs any additional services.
Will you guys send me this information today?
Yes, sir. Well, okay. As soon as the court signs the order, you'll receive a copy in the mail.
Okay.
Oh, if you put your email address in copy the email address out of the chat, which is court120@dhs.ga.gov. Send a message to that email on Friday or after Friday, and we'll send you a copy of the order.
Can you? I don't have it in my chat. Can you say it to me one more time so I can write it down?
Yes, it's court COURT 120 at dhs.ga.gov.
At DHS
GA.gov.
And you said I need to send an email to you guys, or you?
Yes, if you will send an email to us so that we have your email address, we'll send you a copy of the order.
Okay, so
Thank you.
All right, so I just went on the system now, and the arrears balance is only $3,277.59.
It's not an updated number.
Do you guys?
The updated number is $3,277.59.
Updated number.
Do you guys
Mr.
still
Tillis,
need me?
no, sir.
The order has only been in effect since 2021. It's only 2023.
Thank you, Mr. Tullis.
Your Honor,
This is why I don't
Mr.
like
Tillis.
y'all. Y'all don't care what's
Yeah,
right. And this is what I be talking
Thank you,
about.
sir.
She's going off.
I do not owe no $4,000. I only owe $3,277.59, and that needs to be the balance of the owner arrears.
The number that is on
you don't add $1,000. No, ma'am.
Yes, ma'am. Yes, ma'am. Yes, ma'am. The number that is on the system is not an updated number. The number on the system, once again, is not an updated number. It is behind. Stop unmuting, because the more you talk over me, I will continue to mute you. I'm telling you that the number that shows up on the system is not an updated number, but you refuse to listen to me.
Ma'am, when will I
It
get
is not an updated number.
You
are not listening. Okay, unmute yourself one more time, and I will remove you. That's it. Goodbye. All right.
Yo. I don't understand it, right? Why people even be crashing out in court? That's a situation where it could easily go bad. If they want to, they could literally put you in jail. Why are you even arguing? But the level of entitlement that certain people have to talk like that, because they know that a lot of times they won't face the consequences of their actions. But it's crazy how you're on the other side of the table to which you have to pay child support, which is really hard to prove in most cases. For guys to really win full custody of the child and to have a woman even still pay that means that you really must have been fucking up. And the fact that she's on the other side of the table and she's still going off is like OD scary, because it's like your fam, like, she don't understand authority. She don't understand hierarchy. Because it's obvious, the judge is speaking. You be quiet and listen. You're not supposed to intervene when they talk. You be quiet and you listen. Simple as that. You see how when a guy was trying to talk about certain things that were irrelevant, when the judge spoke, he just shut up. He got quiet real quick. He said, "Oh, my bad, I'm sorry," and stopped, and did not intervene again. But in her situation, she just couldn't help it. But you can see why her case went the way it did, and it's gonna keep backfiring on her if she don't stop. She don't control her anger, like control the way how she talk and stuff like that, man. That's really just what it falls down to, or what it boils down to. And some people don't understand that. They don't understand authority. They don't understand hierarchy. They don't understand how to shut the fuck up. And this is one of those cases, and it backfired on her. And she still got to pay that $4,000 and some change. She's really more so concerned about what she owed from 2022, which was around $2,600. Then in 2022, which she said it was around $2,600, and then I believe 2023, which was around $1,300 some change. So you put all of those together, added it up. She calculated around $3,900, but what the judge quoted was that's not an updated amount. The updated amount would be around $4,000 and some change, which she's trying to dispute and she don't want to pay. So she didn't deny that she owed anything. So it's obvious that she had been missing payments and she has been missing child support. Those are things that are valid. So maybe there might be penalties and late fees that was included or other things, etc. But it didn't go in full depth with it. But see how crazy it is when the rose is on the other foot. They can't handle it. But yeah, make sure to like, comment, subscribe, and hit that notification button. Deuces.